Hello? Welcome, TILLI, to the next to the last TILLI for the season. Don't forget, don't come here on Thanksgiving Day. We won't be here. And there won't be any lunch, so don't come. We just wanted to grow your attention that there is birthday cake, and it's for Rhoda Wald, who isn't able to be with us. So we're going to have birthday cake in 2 weeks again, when hopefully she'll be here. We found a pair of sunglasses that were left on the table this morning. If anybody knows, if you know who it is, we have the sunglasses.
At the end of the talk today, we're going to do some candle lighting. So before we go to class, the way I guess we're number 6. We're going to be on the 6th night, so we will be shown on the temple little high notes. There'll be a little video of us lighting the candles on the 6th night. So please come up after the talk, and we'll do this for the temple. That's it. And Bob?
Thanks very much. I'm happy to introduce today's speaker. This is the 5th speaker this fall. We don't have a speaker on the last day. So far I have 4 slots filled for the spring. Often I get ideas from the community. If you have a thought yourself about yourself or a friend who might be a good match for us, do let me know. Today's speaker, Robin Gorenberg, she's a graduate of Brandeis and also BC Law School, and she's been practicing estate planning and probate for over 30 years. She handles all types of estate planning, from basic to complex, assisting young parents with simple wills, naming guardians for children, assisting wealthy clients, and so on. She also provides support after a loved one passes away, navigating the legal process. Today, she'll talk about estate planning basics, wills, trusts, and related documents. Welcome, Robin. You've got, yeah.
Great. Thank you, everybody. Oh, wow, applause before I even speak. That's pretty good. Let's see. Can everybody hear me? No? Okay. Oh, wait. Okay. That's what we need. We need it tightened. Can everybody hear me now? Okay, great. Yell out if you can't hear anything. And also, there's questions and answers at the end, but feel free to raise your hand in the middle. Sometimes it's easier to ask questions when I'm in the middle of a topic. Also, is that better? Okay. It's a very uplifting topic, death and taxes, but it's very generalized. Some things might apply to some of you, some things might not, but it's just to give you a basic idea. And anyone is feel free to email me afterwards with any questions. Also, if anyone wants a copy of the PowerPoint, feel free to email me, and I'm happy to email it to you. So again, just raise your hand in the middle if you have any questions. So this is about estate planning, which is not necessarily for the wealthy. People often say, well, I don't need estate planning, I just need a will. It really encompasses everything: wills, trusts, related documents, anything to do with planning for death, and actually a big part of it is also planning for a lifetime when you can't make your own decisions. So this is going to cover everything. So we're going to go over the basic documents, different kinds of trusts, a little bit about estate taxes and probate, and some other topics that we'll get to. So as I mentioned, it's not just for the wealthy, and it's not just for death. It's planning for what happens to your assets at your death, but also managing your affairs during your lifetime if you're unable to. Okay, so the 3 basic documents that everybody should have. I'll just hold this. The 3 basic documents that everybody should have, no matter what age. A will. Probably no one in this room has minor children, but if you have grandchildren, their parents would need a will. to provide for guardians for their children up until age 18. You also name in the will something called a personal representative. That used to be called executor, but now it's referred to as the generic personal representative. The other two documents that everybody should have, I call the lifetime documents. One is a power of attorney, and that's for naming somebody to make your financial and general type decisions during your lifetime. So you could have a broken leg and can't get to the bank. Somebody that you name as power of attorney could go and sign your name for you at the bank or pay your bills. There are two types of powers of attorney. The more common type is the immediate type. So in other words, it's for incapacity but also convenience. For example, the broken leg. If you feel very nervous about naming somebody with such a broad power, you can do what's called the springing type, which means it springs into effect only if you're incapacitated. The negative is that it causes some delays because in order to use it, the person who you've named has to have proof, such as a doctor's letter saying that you're not able to handle your own affairs. And the third document that everybody should have is a healthcare proxy. It's sometimes referred to, mostly in other states, as a power of attorney for healthcare. Here you name somebody to make your medical decisions if you can't make or communicate them. It's usually involved with something like surgery or end-of-life decisions, but it could be, as simple as getting a tooth pulled and you're under anesthesia. So it's really any time that you're unable to make a medical decision. It usually includes something called HIPAA authorization, which is sometimes a separate form that doctors will have you fill out, but it allows the person you're naming to get information about your medical situation. And the healthcare proxy is not, by law, effective unless you're unable to make your decisions, as opposed to the power of attorney, which can be immediate or only upon incapacity. Any questions? Okay, in the healthcare proxy, you can include certain things depending on your personal preference. One is called a living will, and often people get confused because it has the word will in it, but it has nothing to do with a will. Living will is your statement that you don't want to be kept alive by machines if you're brain dead, essentially. It's very different from a DNR. People often confuse them. A DNR, you don't put in any of these documents. A DNR is something you just do with your doctor, and really, primarily if you have a terminal illness that you don't want to be resuscitated. The living will is that you don't want to be on machines for years and years. Actually, Massachusetts is one of the few states where living wills are not legally binding. But if you feel strongly about it, which many people do, having it written into the healthcare proxy allows your named agent and your doctors to know that it's your instructions. The other thing that some people put in is organ donation, but it's also wise to sign up with an organ bank and not just have it in the healthcare proxy document, because the healthcare proxy document only comes into play if you're unable to make your decisions. There's also something called a MOST, which stands for Medical Orders for Life-Sustaining Treatment. This is a completely separate document. You still need a healthcare proxy, but this gets very specific about what you want and don't want under certain circumstances, and you set it up with your doctor, and it becomes part of your medical record. Okay, so we're done with the basics, which is the will, the power of attorney, and the healthcare proxy. You could just have that as your estate plan, but you do have options for different types of trusts. And this is just to give you a bare bones, basic introduction, and you would decide on your own factual scenario whether you needed something like this. A single trust allows you to provide for certain beneficiaries if you want them to receive their share later, such as grandkids. It also allows you to avoid the 1-year probate process in Massachusetts, primarily for real estate, and we'll get into probate in a few minutes. Most other assets already avoid probate by naming beneficiaries. So that's the single trust. The 2 revocable trusts allow you to get what the single trust does, which is later ages and avoidance of probate, but it also allows saving estate taxes. So we'll get into estate taxes in a few minutes too, but these are more complex, but they can save your children a lot of money at your death. And this is, less common, but there's something known as an ILIT, which stands for Irrevocable Life Insurance Trust. And it allows you to remove the value of life insurance. Many people don't realize, someone might say, how much is your estate valued at? Well, I have a $1 million house and a $500,000 brokerage account, so it's 1.5. But I have a $3 million life insurance policy. The life insurance policy is included with all the assets that get added up at your death to determine whether there's an estate tax due. So if you had the 1.5 plus the 3 million, your taxable estate in Massachusetts is $4.5 million. And if it's over 2, there's a tax. So if you have a substantial amount of life insurance, you can actually save estate taxes on that. Okay, so when someone dies in any state, there's a possible federal estate tax and a state estate tax. This is on top of income taxes while you're alive. This is only at death. So no one, hardly anybody, needs to worry about the federal estate tax because as of January, it's $15 million a person, $30 million combined for spouses. And if you happen to be over that amount, the tax is 40% on only the excess over that amount. Now, Massachusetts is much lower. Massachusetts is one of the worst, I hate to say it, but one of the worst states to die in. There are a few that are worse. New Jersey is one of them. But we actually doubled our threshold in the last year, so it's better than it used to be. So right now, the threshold is 2 million. It used to be 1 million. And back when it was 1 million, if you were over $1 million at your death, the entire estate was taxed. Now, not only is it doubled to 2 million, but only the excess over 2 million is taxed. And it's taxed at 7.2 to 16%. If you're married, there's no tax when one of you dies, because whatever you leave to each other gets what's called a marital deduction, which is 100%. So if you're single and over 2 million, there'd be a tax, and if you're married and over 2 million, there'd be a tax at the second person's death. So we talked about the 2 trusts a few minutes ago. So what the 2 trusts allow you to do for estate taxes is they allow you to double the 2 million for a married couple. So if you're married and you have 3 million or more of assets, the 2 trusts allow you to pass 4 million to your kids instead of 2 million to your kids with no tax. And there are some negatives. It's definitely more complicated than simpler types of trusts. You have to separate out your assets, and after the first person's death, the survivor has to administer this separate trust. But it saves a substantial amount of money for your children or whoever your heirs are, so it's something to learn more about if you're in that scenario. And again, the less common irrevocable insurance trust, this is good because it works for singles as well as married couples. If you have that $4.5 million estate that we just talked about, and you put your $3 million of life insurance in this trust, it's not counted when you die as part of the estate tax. Okay, so that's estate taxes, and here's probate. One thing that's really important to remember is probate and estate taxes are 2 completely different things. Often clients will come to me and say, we're avoiding probate, therefore there are no estate taxes. Completely different. Estate taxes, as we've talked about, is solely based on the value of the estate. If you're over 2 million, that's about it. Probate has nothing to do with the value. It's the process that you go through after your death through the probate court, and it only applies to assets in your name alone. So it has nothing to do with the value, but it has to do with how things are owned. So the only assets that go through probate are assets that are in your name alone, because anything owned jointly automatically goes to the joint owner, so probate is not necessary to retitle the asset. Similar to joint ownership, anything with a named beneficiary doesn't go through probate because it automatically goes to the beneficiary. So typically these days, real estate is the major asset that goes through probate because IRAs and 401ks and retirement plans and life insurance all allow you to name beneficiaries. And different from years ago, just plain taxable financial accounts typically allow you to name a beneficiary as well. Sometimes it has a different name, like they might not allow beneficiary, but they allow pay on death or transfer on death, which is known as POD or TOD. So those all allow you to avoid probate. The process, it's a 1-year process at least in Massachusetts. Other states have different time frames. The reason it's 1 year is because under Massachusetts law, creditors of an estate have up to a year after death to file a claim against the estate. So you can't close it out until you know that there are no creditors or who they are. So it is at least a 1-year process. Things can happen during that year. For instance, real estate can be sold, but the proceeds from that sale have to be held until 1 year after date of death. So it's worth avoiding probate. It's not a huge deal, but if you're setting up trusts for other reasons, it may be worth avoiding probate for the real estate. Any questions? Or is it just very easy to understand or completely confusing? Okay, so a special needs trust. I wasn't going to touch on that because it's sort of outside the realms of, basic documents, but the question was about special needs trust. So you can set up a trust or even a share of one of these other trusts for a beneficiary who may be on or entitled to government benefits. And typically, it's pretty simple. If that person doesn't get the money, but the trustee just has discretion to use the money for their needs, then it's protected. And it won't forfeit their government benefits. Yep. Correct. So if real estate is titled in the trust, it does not go through the 1-year probate process. To give an example, though, it still would be part of whether your estate is over $2 million. It's totally separate from estate taxes and probate. Okay, so how to avoid probate? So for individually owned assets that don't have a beneficiary, primarily real estate, you can retitle the real estate into the trust. So this is done by a deed from you to the trust. And by the way, the trust is you while you're alive. No changes for income taxes. It's really just a paper transfer. So in Massachusetts, we record 2 things to retitle real estate. One is the deed, and the other is called a trustee certificate, which is a very brief summary of the trust. So we don't have to record your whole estate planning trust at the Registry of Deeds. And the third thing we record that I'll talk about in a little while is something called a homestead, which is allowed for trusts. So we record that as well. Now, it's also important if you have real estate or tangible personal property in another state. That would be called ancillary probate, which simply means a second probate that your heirs would have to do at your death, not only Massachusetts, but let's just say Florida. So if you're setting up a trust to avoid probate, you would want to retitle your Massachusetts real estate into the trust, but also have an attorney in the other state retitle your real estate in the other state to your trust as well, so that your heirs avoid all probates in all states. And again, at the bottom, just reiterating that probate and estate taxes are completely different. Any questions? Okay, so here are the decisions that have to be made for your estate planning. When I work with clients, I give a whole list of to-be-decideds. So in the will, you name the executor, which is now called the personal representative. If there's no probate, by the way, the will is moot. So the only assets that go through the will are assets that go through probate. And the personal representative basically gathers the information about your assets, signs the probate forms if there is probate, and basically works with all the other, team in your life, the financial advisors, tax professionals. Again, if any of you have minor children, or if your children do and they have to do their wills, the will is the only place where you name the guardian for minor children. So it's very important for young families with young kids to have wills. And that ends at age 18, the guardian. You can name 2 people as guardians, but it's also very important if you do that to decide if only one of them is alive, do you want that one person as guardian? Often it'll be a sibling and their spouse. So a lot of people will say, you know, really it's my sibling, and if he's or she is not living, then the next couple. And based on the other documents we talked about, here are more decisions to be made. Healthcare proxy, you're going to name somebody to make your medical decisions if you can't make them. And you would normally name the same person for that HIPAA provision, the ability to get information about your medical circumstances. And by the way, often people will name the same person for a lot of these positions, but for example, if you're naming your children for different positions, often one will be named as healthcare proxy and the other will be named as power of attorney. It's whoever's best for the job at hand. Usually power of attorney and trustee and executor is somebody who's very organized, but it may be that for the healthcare decisions, that's not the same person. And again, in the power of attorney, you're naming somebody to act as you for financial and legal actions, dealing with bills and taxes and bank accounts, and you can decide whether it's immediate or springing. If you do set up a trust, either the single trust to avoid probate, or the double trusts to save estate taxes, or the insurance trust or a special needs trust, you need to name a trustee who would be the trustee after your death. Normally, you're the only trustee while you're alive, so you retain complete control. And that trustee is going to be in charge of, after your death, distributing the assets the way you determine in the trust, possibly holding a trust share for a certain amount of time if a beneficiary is getting it at a later age, and also dealing with tax professionals, filing tax returns for the trust after you die. Again, while you're alive, the trust is usually you for tax purposes. And then the main decision is, who are your beneficiaries? This would be the case whether it's in your will, whether it's in your trust, or whether it's naming direct beneficiaries of financial assets. And it's important to decide, if you have a certain amount of beneficiaries, what happens if that person's not alive? Would it go to their kids, or would it go to other people? Also, if there are young children involved, and young could be even mid-20s, do you want them to get their share at your death, or do you want it to be held until more mature ages? And it's also important to decide how to pass your assets if you leave no children or grandchildren. If you don't say anything, it would be your next of kin, which would be parents, otherwise children, otherwise siblings, otherwise nieces and nephews. Okay, so here are some additional documents, aside from the wills and the trusts and the powers of attorney and healthcare proxies. If you own real estate in Massachusetts, there's something called the homestead. It recently increased from $500,000 to $1 million. If you're married and both over age 62, it's $2 million. And it's also allowed if the property is owned in a trust. If you don't record a homestead at the Registry of Deeds, you get an automatic $125,000 of protection. If you need more than that, if the equity in your home is worth more than $125,000, it's worth putting this one simple document on record, because it protects you from creditors or lawsuits. So if you got sued, let's say you had a car accident and the settlement was more than what your auto insurance policy provided for, and they put a lien on your home and you sold it, they would not be able to touch the first $1 million or $2 million of equity. Any questions about that? Most people who buy real estate now, usually the homestead is part of what the real estate attorney records, but it's good to check and see if you have one. There's actually a website called Mass Land Records, M-A-S-S landrecords.com, where you can go to the county and then check on your recorded real estate documents. And here's documents for college age or adult children. Once people turn age 18, their parents can no longer legally act for them. So it's important after age 18, whether it's a grandchild or a child, that they each have a power of attorney and a healthcare proxy, so that if something happens to them, they have someone in line to sign their name or make their decisions for them. Oh. All right, we're done with all the topics. Anyone have questions? I was even surprised by the ending myself. Questions? Okay. I speak very loudly so that everybody in the room, oh, we have a mic, great.
Yeah, in the case of a trust, you talked about the personal representative being, I'll say, responsible or involved in the estate taxes. Once the estate is settled and the trust is distributed to different, children, for example, how are income taxes handled then?
So let me just get the question right. So first of all, the personal representative is for the will, just to clarify, if there's probate. So it's the trustee of the trust.
Trustee, sorry.
So you're saying that once everything's completely distributed, what happens?
Yes.
So I'll give you a little step behind that too. So if it's a standard revocable trust that the person has control over, so let's just say it's your trust. So, and you're leaving everything equally to your children, and you name one of the children as trustee? Okay. So at your death, the trust then becomes irrevocable, and it gets a new tax ID number. While you're alive, it's under your Social Security number. And then if everything gets distributed and doesn't get held for any beneficiary, that child who's the trustee would distribute all the trust assets to your children equally. They'd probably have everybody sign off what's called a receipt and release of their inheritance. And if there's enough income between date of death and date of distribution, the trustee would have to file income tax returns for that year. But if there isn't enough, like if it's distributed a month after and it's real estate which didn't have any income, then there would be no requirement for an income tax return. Does that answer the question? Okay, great. Yep, go ahead. Oh, you know what? He's going to bring the mic over to you. Right up in front. He's coming. Right behind you, he's coming.
Oh, thank you. Would you mind reiterating about the springing
Yes.
trustee? I think
So
I
that's
missed
the
some
power
that.
of attorney.
Okay.
So the power of attorney is only while you're alive. And it's naming somebody to basically be able to sign your name for you. So they could go to the bank, they could put your house into a trust and sign your name to the deed. So there are two types. One is the immediate type, which means that the moment you sign it, it's effective, so that it can be used for convenience. You could be in Florida for the winter, and if you named your daughter could go to the bank and do something for you. If you choose the springing, which is a lot less common, it's just a little more protective. It means that the person you named can't act unless they also have proof that you're incapacitated. And that would be some sort of a letter from your doctor having evaluated you and stating that you're unable to manage your own affairs.
And is that something that needs to be spelled out in your documents?
In the power of attorney document, it will say towards the beginning, in my form, most of them do.
Mm-hmm.
In the beginning, it will either say it's immediate or it's not effective unless a doctor attests to my incapacity.
Okay, thank you.
Yep, in the back.
So these may be highly specific questions, but so if the conditions of a trust, let's say in this case a revocable trust, specify that when the living trustee, let's say, is incapacitated, leaving behind another trustee, let's say a child, that a disinterested trustee must then substitute for the person who's ailing, a so-called disinterested trustee. I wondered if you would comment on that category, but before you do, how a trust and estate's attorney can actually be in that setting a disinterested trustee, since as they're working on the trust and doing those functions, the meter is running. So that's because they're hardly disinterested. So point one. And my second question, also specific, is tax and trusts and estates litigation. So usually that's bifurcated, I guess, from the people who actually draw up the wills. Like if there's a fight that comes out of this stuff, which is, after all, part of the fun of it, right? Is the fun of it is
Not in my opinion, but
not in my opinion either, but unfortunately it happens. Is there a recommendation that when these documents are drawn up, if there's anticipation of that they be drawn up with a larger firm that has its own in-house stable of litigators to deal with the fallout of such a thing, or is that, how would you recommend
I'll answer
that
your
be
second
handled?
question first, and
that
then I
always-
might need you to remind me of the first
Right,
question after
that's
that.
usually how the game is played, right?
So about litigation, I don't think it matters if it's the same firm or not, but it definitely is a separate type of attorney because they not only need to know about estate planning, but they need to be a litigator. And most estate planning attorneys are not litigators. So I think a bigger chunk of a fight in estate work has to do with litigation than it does with estates. So I do think it's best, like I've referred people to, if somebody comes to me as a new client and says, my brother's the executor of my mother's estate and he's not giving me information, I refer them to an estate litigator. Even if it doesn't go to litigation, that's the attorney that's going to be able to work through the issues with the family. And your first question was about independent trustee. So not all trusts require an independent trustee. The legal definition of independent trustee is a trustee that has no interest in the trust, in the assets. So for instance, if you required an independent trustee and your kids were the beneficiaries, they could be a trustee, but there'd have to be another trustee who is truly independent. Your thought about naming an attorney as trustee and how could they be independent if they make money on it, that's not under the definition of independent trustee. Now, it is certainly something to think about. I actually don't serve. I don't serve as trustee or executor, but I have friends who are attorneys that do. But they have a fiduciary duty as trustee or personal representative. So if they overbill or if it has anything, not proper, they could be sued for that or, asked to reduce their bill. But you're right, there's a conflict of interest, but they have a fiduciary duty. Does that answer the questions? Okay, great.
So I'm curious about what happens when somebody doesn't do any of the right things. So that's my family for you.
Okay.
So my uncle, who died in 70-something, had stocks. He died, they went to my aunt. She told my father, you can have them, but there was nothing on paper. So it's still in his name. My aunt and my father are now long gone, and I know there's these stocks, and my aunt and uncle had no kids. They do have the 4 nephews and nieces and another nephew. How, is there any way, like where would you even begin? I don't even know how much it's worth, and I don't know how.
So probate would be required. So who was the last person to die of that group?
My father.
Your father. So did you go through his paperwork and find the stocks?
We have all of these statements that.
Okay, so you have the statement, so there's probably a phone number on the statements. So you would be able, so your father died last, and he was not married at his death?
Oh, he was. My father was married. She's gone too. Nobody's left.
Okay, but if she survived him,
No.
did he have a will?
Doubtful, but I don't know.
Okay, so he
whoever
died. So
recounted
he
his
died
name,
last of his sister and his wife.
His brother and his wife.
So at his
but it's
death, he didn't leave a spouse,
brother's
but he
name.
left kids.
What?
He didn't leave a spouse, but he left kids.
Who?
Your father.
Oh, she predeceased him.
Okay, so he's the last to die,
Yes.
and he left children.
Yes.
Okay, but no spouse.
She predeceased
She
him.
predeceased him. So at his death, he had no spouse.
Right.
Okay, so if he didn't have a will, it goes by what's called intestacy. And the Massachusetts intestacy laws, and most states' intestacy laws are very similar, means that the next in line are the kids. So without a will, it's the same probate process as it is with a will, but it would just go to the intestate heirs, which would be the children. Yep.
The complicating factor is that those statements are still in my uncle's name. It was only an oral promise.
Okay, so
that
they're in your uncle's name, and at his death, he left a spouse.
Yes,
Okay, so, and they had no beneficiary or joint owner. Did he live in Massachusetts?
New Jersey.
New Jersey. So you'd probably have to do New Jersey probate to get it to whoever survived him, and then that person's probate to get it. So you'd have to do a couple of probates, but if it's worth, you know, even like 10,000, if it's worth more than the cost of doing the probates, then it's worth it.
Okay, thank you.
Yeah. Yep. Oh, wait, he's coming with the mic.
What happens to when you have IRAs and things and you have to give state tax because I don't know the term. You get it every year and it tells you
Yep.
how much you have to
Yep,
get
I'll-
rid of your.
Yes, that's an excellent question, yep. So IRAs and retirement plans, like IRAs and 401ks, you name a beneficiary. So this is like a good answer because it combines all the things we learned plus one thing I didn't teach you. So it avoids probate because it names a beneficiary, so it doesn't go through your will. If your total estate, including the IRA, is over $2 million, there's going to be an estate tax. But now there's an income tax issue. So while you're alive, every year you have to pay what's called RMDs, required minimum distributions. At your death, there are still income taxes that are due. So it depends on who the inheriting beneficiary is. If it's a spouse, they get the best post-death income tax treatment in that they get to roll it over into their own IRA and then take their own RMDs as required. Anyone other than a spouse, there's a fairly recent thing called the Secure Act, which means that anyone other than a spouse has to take distributions from the IRA within 10 years after death. It used to be, before the Secure Act, that they could take it over their lifetime. But now it's a 10-year rule, whether it's a person or a trust. So you could take it day one, you could take it day 10 years, or staggered along the way. But whenever they take it, they owe income taxes on it.
So if you have combined trustees, like grandchildren, poor soul who gets the IRAs has the problem, doesn't it? The other sisters, brothers, grandchildren, they are getting different parts of your asset.
Exactly. So if somebody gets an IRA, let's just say you give $1 million IRA to one person and $1 million brokerage account to another. The one with the IRA is going to get less because they're going to owe income taxes on it. So that's why if you have children, for example, you wouldn't leave an IRA to one child. You would leave the IRA equally to the children, and you'd leave the brokerage equally to the children. Or you would take into account the decrease in value because of the taxes, or you might not care and you might just say, this person's getting this. You know, it depends on your group of people and how you want things to pass, but it's definitely something to consider, that that person who's inheriting the IRA is going to end up with less than what that IRA is worth.
But now also my question is, if you are the surviving spouse, you have two IRAs.
No, because you actually get to roll over your late spouse's IRA into your own.
So you don't have to, but then when you get the notice of how much you have.
You're going to owe more every year because you have a bigger IRA.
Oh, that's
Yeah.
what I thought.
Yeah.
Terrible.
Well, it's not, it's terrible, but it's all terrible. Look, it starts with death and it ends with taxes. It's all terrible. Although they do call it Taxachusetts for a reason, but
It's not a joke.
But yeah, it is all terrible, but it is better treatment than the people that have to take it within 10 years.
Okay, so the person you've left it to that has to take it within 10 years, I guess you're advised which person you should do that with, the youngest person or something.
You know what? I always advise that whoever those beneficiaries are, they consult with their own financial and tax people to determine based on their financial structure what's best for them as far as when to take the distributions. But if your question was determining who you would give the IRA to, who's going to have to pay that tax versus other assets, I think that's a very individual fact situation decision.
For the family or for the person who is going to die?
Well, the person who's going to die's decision as to who they're naming as beneficiary, so it's really their decision. But as far as age, it doesn't really matter because either way, it's 10 years. I mean, you could leave it to somebody who you believe is going to be in a lower bracket, but that could also change by the time you die. So it's very individual.
Okay. Thank you.
All right, good questions. I just want to, oh, good. We still have time for the Hanukkah thing, so okay. Hanukkah takes precedence over death.
You said the Massachusetts tax was 7.2 to 16? Oh, after 2 million. Can you
It's
explain
7.2 to 16%. It's a graduated rate. So if you're over 2 million, so if you're at like 2.3 million, it's going to be at the 7.2%. And if you're up to like, 4 or 5 million, it's going to be at the 16%. But it's only on the excess of 2 million, which is very different than the prior law.
Okay, thank you.
You're welcome.
Hi, could you just explain the difference between the trustee and the executor?
Yes. So she asked about the difference between executor and trustee. Executor, I still use the word executor too, even though it's called personal representative. One funny thing, by the way, I had a paralegal years ago. It's spelled the exact same way. She used to keep calling executor executor. It was funny, but not. Anyway, the difference is the executor or personal representative is in charge of the will, which means they're in charge of probate. So the will is just a letter to the court. If there is no probate, because you've named beneficiaries on everything and either don't own real estate or you've put it into a trust, then the will never gets probated and the executor never gets appointed. The trustee is the person who's in charge of a trust if you have it. No matter what the trust says, they're in charge. So if it gets distributed equally to a certain amount of people, that's their job. If it gets held for kids until age 35, they've got to create different shares and manage those until those ages. So if you have a trust, the trustee is the more major job than the executor. Good questions, though. Any other? We have one out in the back. You're getting your runaround today. Oh, I work out of my home office in Brookline. I do most of the work virtually, so a lot via email and Zoom. Is that it?
Thank you, Robin.
Okay, perfect timing.
Happy Hanukkah.
Thank you.
All right. Thank you so much. And thank you all for your patience. I know Hanukkah still feels like a couple weeks away. We're not even at Thanksgiving yet. If you all